The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now, the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA 3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1. The definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to union territories. And 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
तो बड़ी खबर आपको बता दें, सुप्रीम कोर्ट से दिल्ली का जो निर्णय आया है, दिल्ली सरकार के लिए अच्छी खबर है कि फैसला दिया है कि अधिकारियों की ट्रांसफर, पोस्टिंग और सर्विसेज का अधिकार जो है वो दिल्ली की चुनी हुई सरकार को सुप्रीम कोर्ट ने सौंपा है और कहा है कि दिल्ली अपने एक पूर्ण राज्य नहीं है और ना ही किसी और यूनियन टेरिटरी की तरह है, एक केंद्र शासित प्रदेश की तरह नहीं है, बाकी केंद्र शासित प्रदेशों की तरह भी नहीं है, लेकिन दिल्ली में लॉ एंड ऑर्डर, पब्लिक ऑर्डर, लैंड और पुलिस को छोड़ करके बाकी जो अख्तियार हैं वो चुनी हुई सरकार के पास होने चाहिए। अधिकारियों की ट्रांसफर, पोस्टिंग का अधिकार भी चुनी हुई सरकार के पास होना चाहिए। अगर अधिकारियों पर अख्तियार चुनी हुई सरकार के पास नहीं है, चुने हुए प्रतिनिधियों के पास नहीं है, तो फिर सरकार काम नहीं कर सकती।
इंडिया टीवी हर वक्त हर जगह डाउनलोड करने के लिए सर्च करें इंडिया टीवी न्यूज गूगल प्ले स्टोर या ऐप स्टोर पर।